Breaking news. Welcome to today's headlines. Nnamdi Kanu's case. Lead counsel Ozekome has reviewed the huge error done by the Nigerian Federal High Court in the recent Kanu's bail dismissal. Nnamdi Kanu's case. Lead counsel Ozekome has reviewed the huge error done by the Nigerian Federal High Court in the recent Kanu's bail dismissal. So, my dear listeners, from wherever you're listening from, please stay tuned as I read today's news. The Federal High Court, Abuja delivered an erroneous ruling in the case of the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, the head of the Defense Council's Chief Mike Ozekome-san, has said. Ozekome disclosed this on Thursday, according to a statement released during a routine visit to Kanu in the facility of the Department of State Services, Abuja. In the statement released by Ifeanyi Ejiofor on Friday, the IPOB leader noted that he was committed to ensure total peace in the southeast region. Ejiofor said they were aware of the plot by government sponsors and agents to frustrate and work against the efforts to secure the release of the IPOB leader, adding that they were not deterred by the development. Barrister Mike Ozekome-san reviews secrets of Mazi Nnamdi Kanu's bail denial. While clarifying the ruling delivered on Tuesday, June 28, 2022 by Justice Binta Lunyako, the statement said it was never based on a second bail application by Kanu's team of lawyers. Rather, it was a ruling predicated on an application to vacate an earlier 2019 order made by the same court which had revoked Kanu's bail, leading to the court issuing a bench warrant for his arrest. The statement noted that the application which the court ruled upon was filed as far back as April 1, 2019, and not 4 years after the incident as the court erroneously held. The statement read in part, in line with the court-ordered written visit, we visited our indefatigable client, Onyedu Mazi Nnamdi Kanu, at the DSS headquarters, Abuja today. Today's visit was eminently led by our legal Iroko, Chief Mike Ozekome, Mazi Nnamdi Kanu's lead defense counsel. It is to be noted that the defense team, ably led by Chief Mike Ozekome, San was not taken aback by the development in court on June 28, 2022, and neither was Oyedu himself taken by surprise. We are not unaware of the fact that the executive is desperately frustrating every positive effort being made in court to bring innocent Nnamdi Kanu out. However, we are not in any way deterred by these state-sponsored tactics from firing on all cylinders to ensure the unconditional release of Nnamdi Kanu in the shortest possible time. We had good quality time with Onyedu, who is unshaken and unfazed by the antics of those determined to dampen his spirit. Rather, he maintains that his primary focus now is to ensure total peace in the entire southeast, while appealing to Umuchineke to be more focused now, more than ever. In his usual effervescent nature, Oyedu thanked you all, millions of his supporters and Umuchineke, for defying every threat to trunk the court in solidarity. He also appreciates those who observed quiet moments in prayers and supplication to the Almighty Chukwu Okike Abiyama throughout that day. He cannot thank you all enough. Our erudite silk and mentor, Ozeko Mesan, seized the opportunity offered by the visit to issue a much needed clarification on some issues. He accordingly urged all to ignore the false and misleading information passed onto the media about happenings in the court by persons whose satanic intent and purposes are to dampen the iron-cast spirit of the solid defense team. These will never happen. To this end, the Land Silk hereby unequivocally make the following clarifications. The ruling delivered on the 28th day of June 2022 by the Honorable Justice Binta Yako of the Federal High Court, Abuja, was never based on any second bail application by our team of lawyers. Rather, it was a ruling predicated on an application to vacate an earlier 2019 order made by the same court which had revoked Oyedu's bail, leading to the court issuing a bench warrant for his arrest. The said application, which the court ruled upon, was filed as far back as 1st of April 2019 and not 4 years after the incident, as the court erroneously held. These clarifications are compelling because almost all the social media platforms and leading television stations acted on the wrong information mischievously dished out by persons who ought to know better and who are supposed to be concerned about Oyedu's immediate release from the DSS. To my dear listeners, now we've come to the end of our today's news. Please do drop by at the comment section and let us know what your